Hello there. I'm Catalina Goanta, Assistant Professor in Private Law and Technology at Maastricht University, and together with my dear friend and excellent researcher in constitutional law, Giovanni de Gregorio, who is currently doing his PhD at the University of Milano-Bicocca, we're making this video to share with you some thoughts and arguments from our upcoming paper on the Influencer Republic. Here's what we mean by that. In February 2020, Mike Bloomberg's campaign for the presidency of the United States started collaborating with Instagram influencers. For a $150 fee, the Meme 2020 project, led by the Instagram-savvy owner of a well-known meme account, started asking various influencers to create content for Bloomberg in an attempt to increase his popularity and reach on the social media platform. Constitutional models of political speech online, such as Jack Balkin's free speech triangle, acknowledge relationships between digital platforms, states, and users. Yet there is an emerging category that deserves a more prominent place in discussions relating to the content creation and monetization process that happens on social media. That category is content creators. Also called influencers, content creators are individuals who make content on social media with the hope that they can monetize it in various ways. So far, influencers have been acknowledged by the growing body of literature on influencer marketing, consisting in the creation of content on behalf of brands which pay or offer goods or services in exchange, in the context of disclosing paid advertising. However, unlike legacy media, where the advertising industry has been held to more stringent transparency, influencers often blur the lines between what they believe and what they promote. This is particularly worrying if we consider that social media platforms are coming up with various ways of controlling political ads, ranging from banning them completely, the case of Twitter's policy, or limiting their reach, what Facebook is doing. What these actions do, in fact, is create a window of opportunity for the growth of content monetization on social media, with the risk of further blurring the lines between commercial and political speech. This paper aims to investigate this matter by addressing the specific challenges arising from the monetization of political speech by influencers on social media from the perspectives of constitutional and consumer protection laws. To put rules and practices into perspective, we'll be comparing the US and the EU. We'll describe our paper in 4 acts. I'll start by showing you how political speech may be monetized on social media. Giovanni will then take over and speak about the magnetic effect between commercial and political speech from a constitutional viewpoint. I'll follow up on that by looking at political ads from a consumer law perspective, and Giovanni will conclude by talking about the tensions which constitutional and consumer law lead to in the context of monetized political speech. To better understand the interests of content creators, we must first explore their business models and practices. Social media is a digital Wild West where you can be anything and everything, anywhere and everywhere. Based on prior ethnographic and market research on how content creators, or influencers, however you want to call them, make money online, we can distinguish different avenues. Platform ads. If you display ads, you get paid per view of ad placement. Platform tokens. Users viewing content made by influencers can purchase tokens or alternative currencies which they can spend interacting with their favorite influencer. Influencers can also get income on the basis of subscription models on social media platforms. Influencer marketing. Third parties can pay influencers or offer goods or services in exchange for the creation of native advertising by influencers or the sharing of affiliate links through specific interface possibilities such as Instagram or TikTok's link in bio and social commerce URLs. Direct selling means that influencers can choose to create and sell their own products, also known as merch. And we also have crowdfunding. Influencers can be supported by their followers who enjoy their content. The way in which political speech can be monetized depends very much on who exactly is doing it. Here's an overview of actors we think will increasingly turn to monetization. First, social media influencers as political opinion leaders. A telling example is the case of Rezo, a German influencer known for funny videos directed to a young audience, who in May 2019 surprised his followers with a political monologue in which he vehemently criticized the promises and actions of the German party CDU. Second, we have politicians as social media influencers. Politicians can use their platforms to promote the interests of their supporters and boost their reputation. This indirect quid pro quo does not consist of one transaction or one contract, but rather consists of different actions that are determined by one another. A company offers financial support in exchange for visibility from a politician's persuasive discourse and policy agenda. Lastly, we have social media influencers turned politicians. This is the case of Brazilian YouTuber Kim Kataguiri, the youngest person ever elected to Congress, who still uses AdSense on his YouTube channel where he streams discussions from the country's legislative branch for his over 500K followers. In Kataguiri's case, he even surpassed his initial role as a content creator with political opinions as he took political office. Now the question is, if content creators engage in political speech for commercial gain, to what extent is this speech protected?
So thanks, Catalina. At this point, I think it is worth wondering, so what kind of protection of free speech apply to the statement of influencers online? And this is really a hard question since, as Catalina has already explained with some examples, influencer marketing sometimes tend to involve both advertising statement and in many cases also political speech or statement concerning public or political debates. So the phenomenon of influencer marketing has questioned the boundaries between commercial and political speech, and we know very well that also the protection of commercial speech is not the same of political speech, and also the protection of free speech is not the same in different kinds of jurisdictions, especially when we look, for example, at the protection of free speech in the US and in the EU. So the problem is that a commercial speech, you know very well, that is usually perceived as a liberty, that deserve less protection of other forms of speech, like, for example, political speech, that is being considered the most important kind of speech to protect democratic values, because, of course, it is a basis of the democratic debate. And, of course, commercial advertising is usually considered the core of commercial speech, but it's not always easy to define a clear boundaries of when commercial statements, for example, from influencers, go political, or when, for example, political statements are also commercial nature. And so this is clear, for example, in the case of political campaign, if you think about it. But what we want to focus on is that, especially the case when influencers advertising some products and at the same time they talk about topics of public purposes. This is because what we are trying to do in this work is to define a potential, let's say, tendency towards the attraction of commercial speech within the field of political speech. And this is not something that should be neglected or is neutral. Indeed, the attraction of commercial speech within political speech means that, for example, the statement of influencer marketing could enjoy the protection that is recognized to political speech, and this means also banning some kind of regulatory intervention from public actors in the fields of influencer marketing because of the kind of protection that political speech enjoy within a constitutional law framework. And so this is, in order to understand what we are trying to call here in this work, like the magnetic effect, so how commercial speech is attracted within the framework of political speech, we focused on, let's say, on Europe and the US case law, and especially the case law of the US Supreme Court and the European Court of Human Rights, to understand how this magnetic effect works. And in particular, if you look at the US constitutional framework, we know very well that the First Amendment grants almost a quasi-absolute protection to the right to free speech. And when we look, of course, at the protection of commercial speech, it is another story, because also in the US framework, commercial speech enjoy a lower degree of protection of political speech. And now I have no time to tell you or to analyze the story of the evolution of the protection of commercial speech from the Valentine case, then as evolved in Virginia Pharmacy and the Central Addison test. But what is important to stress is that if we look at the US Supreme Court case law, we can find some cases where there is a clear overlap between the field of commercial speech and political speech. For example, in Re Primus, for example, we can see how the commercial speech meets, for example, expression in the public interest. So, for example, in this case, the Re Primus case concerned a lawyer that was informing clients about the availability of legal services provided by the ACLU, And this kind of speech was considered of political nature, even it was in some way advertising of services. But also really, for example, we have seen how these two layers overlap. And because there is also, and the case in particular involved the imposition of a reasonable fee to the solicitation of charitable contribution. And in this case, the court said that, of course, there is a commercial nature of this kind of speech, but also there is also a kind of public interest and political speech that deserve to be protected and cannot be subject to this kind of limitation that was the reasonable fee, let's say. And a similar trend, we can observe a similar trend when we move from the US to Europe and looking at the case law of the European Court of Human Rights. And in particular, for example, just to mention other two cases, like as example, there are also other many cases also in the US. For example, in Barthold, a veterinarian association charged one member with a violation of, let's say, rules of conduct and unfair competition for some statements that this veterinarian published on a newspaper. So the problem was that the court recognized a violation of freedom of expression for this form of injunction from a national authority, because, of course, the national authority did not really take into account the role of these statements and the role of the press in sharing this kind of statement. So this is once again show how even it was in some way something that was statements within the kind of unfair competition and professional conduct, also for advertising banning, this kind of behavior was considered in some way something that can be attracted within the framework of political speech. The same was also in another case where an animal rights association planned an advertising campaign, but this campaign was to encourage people to reduce the consumption of meat. And we know very well that this, in some way, there is a public debate on that. And it's not by chance that the European Court of Human Rights recognized that in this case, this kind of advertising is also political, and so contracting states has a narrow margin of appreciation in regulating or sanctioning this kind of, or restricting this kind of expressions. So in general, there are also, as I already told you, there are also other cases, but what is interesting to observe is that there is this kind of risk, there is this potential overlapping between commercial speech and political speech, and this kind of magnetic effect, where political speech attracts commercial speech and recognizes a broad frame of protection. And also, when we look at between the US and the EU, we can find some patterns. And what in particular is important is this kind of magnetic effect that is clearly shown by the case law of both the US Supreme Court and the European Court of Human Rights. And the problem is that this kind of speech, as we have already said, in some way can challenge regulators when they want to in some way intervene and regulate in some kind of speech or even the influencer marketing environment. And so this is not just a trivial question, because of course if this magnetic effect is so important, of course it is because it affects also the possibility to regulate influencer marketing activities.
Now that we've heard some constitutional arguments about the interaction of political and commercial speech, let's move to understanding very briefly how commercial speech is looked at from the perspective of consumer protection. In the United States, unfair competition, or unfair commercial practices, as they are called, are not subject to a harmonized regulatory framework, but the landscape has been rather defined by Chaffee as courts trying to stop people from playing dirty tricks. To consolidate existing case law and provide advertisers with a cohesive framework of good practices, the Federal Trade Commission drafted the guides concerning the use of endorsements and testimonials in advertising, which will be historically revisited in 2020 after a request for public comments. The most important element of the guides relates to the disclosure of material connections which may exist between a marketer and an endorser. In the European Union, unfair competition rules are brought together in the Unfair Commercial Practices Directive, the UCPD. This directive is a maximum harmonization instrument of consumer protection with the aim of establishing uniform rules of unfair business-to-consumer commercial practices in order to support the proper functioning of the internal market and establish a high level of consumer protection. The directive operates with two types of tests, generally and more specifically ascertaining the unfairness of a given commercial practice. More importantly, the directive also lists practices that are in all cases unfair, such as pretending to be a consumer and actually selling goods and products, misrepresenting social endorsements, or not disclosing paid advertorials. The paper looks into these regimes in greater detail. One key takeaway, though, is that while consumer rules in the US and EU are convergingly requesting more ad transparency, it is unclear whether these rules could apply to political speech, as they are originally meant to target goods and services. As such, a politician is neither of those, but closing a blind eye to the commercial supply chain and the provision of such ads means ignoring the consumer-imbued context they are shared in on social media.
Definitely, Catalina, you're right. And at this point of this presentation, probably you are wondering how to deal with the magnetic effect, precisely if we go back to our example. And I think that the answer to this question mainly comes from the different perspective, once again, of freedom of expression, if we look at the protection of these fundamental rights in the EU and the US. Because on the one hand, we have seen how the magnetic effect is a concern in both sides of the Atlantic. But we should not forget that the protection of freedom of expression in the US, and especially political speech, grants basically a quasi-absolute right to especially to the speaker, to who speaks, and avoid any kind of, and try to avoid any kind of regulation on that. While when we move to the European framework, we can also rely, and we have seen how commercial speech has been highly regulated, and also when it is at the intersection with political issues and public issues. Think about the regulation of tobacco advertising and the difference with the US framework. Because, for example, think about when an influencer can use, for example, a tobacco trademark, even if this influencer is denouncing, is protesting against, for example, and explaining the damage of smoking, the societal damage of smoking, And the point is this kind of speech should be considered political or in some way commercial. And this is not an easy question. Because basically there is a clash between a paradigm of liberty, which is reluctant to paternalism and regulation of commercial and political speech, and I'm referring to the US framework. But there is also a framework of dignity, especially in Europe, which takes more into account the role of public actor in safeguarding other interests which deserve to be protected. Because, of course, especially when we look at the European constitutionalism, the protection of freedom of expression, also political speech, is not the only constitutional interest or interest at stake. There is also other fundamental rights to be protected, like, for example, health or the protection of minors. And also, consumer law is also the result of this kind of different approach to the balance between fundamental rights, where there is not an axiology in the European framework, but there is more an equal approach to all the fundamental rights. And so, just to close this presentation, what we can say is that the magnetic effect is a problem in both sides of Atlantic, and of course challenges regulators in dealing with the influencer marketing. But what we can say is that, of course, the soundness of consumer law in Europe could really help to, in some way, tackle this magnetic effect and address when influencers exploit this kind of magnetic effect to shield their activities within the framework of protection of political speech. While in the US, the protection of freedom of expression, especially political speech, could lead to a more self-regulatory approach involving social media, especially online platforms and influencers. So thank you so much for listening to us, for listening to our presentation, and of course we will be happy to hear your questions.